A. Decisions involving collateral orders in Cohen v. Beneficial Industrial Lowland Corp. 337 U.S. 541, 69 S. Court 1221, 93 L. Edition 1528, 1949. Cohen brought a shareholders' derivative suit in a New Jersey federal court. The district court denied Beneficial's motion to require Cohen to post security for costs pursuant to a New Jersey statute, holding the statute inapplicable to an action in a federal court. The Court of Appeals reversed, and the Supreme Court affirmed that decision. The justices addressed the question of appealability in the following passage. Appeal gives the upper court a power of review, not one of intervention. So long as the matter remains open, unfinished, or inconclusive, there may be no intrusion by appeal. But the district court's action upon this application was concluded and closed, and its decision final in that sense before the appeal was taken. Nor does the statute permit appeals, even from fully consummated decisions, where they are but steps towards final judgment in which they will merge. The purpose is to combine in one review all stages of the proceeding that effectively may be reviewed and corrected if and when final judgment results. But this order of the district court did not make any step toward final disposition of the merits of the case, and will not be merged in final judgment. When that time comes, it will be too late effectively to review the present order, and the rights conferred by the statute, if it is applicable, will have been lost. Probably IRREPARABLY. We conclude that the matters embraced in the decision appealed from are not of such an interlocutory nature as to affect, or to be affected by, decision of the merits of this case. This decision appears to fall in that small class which finally determine claims of rights separable from, and collateral to, rights asserted in the action, too important to be denied review and too independent of the cause itself to require that appellate consideration be deferred until the whole case is adjudicated. The court has long given this provision of J-E statute this practical, rather than a technical construction. We hold this order appealable because it is a final disposition of a claimed right which is not an ingredient of the cause of action, and does not require consideration with it. Here it is the right to security that presents a serious and unsettled question. If the right were admitted, or clear in the order involved only an exercise of discretion as to the amount of security, a matter the 1168 Appellate Review Chapter 16 statute makes subject to reconsideration from time to time, appealability would present a different question. Edit 545, 69 S. Court at 1225, 93 L. Edition at 1536. Will v. Hallock, Supreme Court of the United States, 2006, 546 U.S. 345, 126 S. Court 952, 163 L. Edition 2nd 836. Certiorari to the United States Court of Appeals for the Second Circuit. Justice Souter delivered the opinion of the court. Agents of the United States Customs Service, acting on a warrant, seized computer equipment at plaintiff's home. No charges were brought, and the equipment was returned, albeit in severely damaged condition, resulting in serious financial loss to plaintiff. Plaintiff brought suit against the United States under the Federal Tort Claims Act, alleging negligence of the agents. While that action was pending, plaintiff filed a separate negligence suit against the agents. The action against the United States was dismissed, after which the agents moved to dismiss the second suit on the ground that a federal statute, 28 U.S.C. 2676, barred the action against them once the first case was dismissed. The trial court denied the agent's motion on the ground that the statute did not apply. On appeal, the Court of Appeals for the Second Circuit held that the collateral order doctrine justified the appeal despite the lack of a final judgment, and upheld the trial court's decision. The collateral order doctrine, identified with Cohen, is best understood not as an exception to the "final decision rule" laid down by Congress in 1291, but as a "practical construction of it." The collateral order doctrine accommodates a small class of rulings, not concluding the litigation, but conclusively resolving claims of rights separable from, and collateral to be, rights asserted in the action. The claims are too important to be denied review and too independent of the cause itself to require that appellate consideration be deferred until the whole case is adjudicated. Cohen. The requirements for collateral order appeal have been distilled down to 3 conditions: that an order 1. Conclusively determine the disputed question, 2. Resolve an important issue completely separate from the merits of the action, and 3. Be effectively unreviewable on appeal from a final judgment. The conditions are stringent, and unless they are kept so, the underlying doctrine will overpower the substantial finality interests. 1291 is meant to further judicial efficiency, for example, and the sensible policy of avoiding the obstruction to just claims that would 1174 Appellate Review Chapter 16. This court has described the pragmatic finality doctrine as more subjective than the collateral order doctrine, involving ad hoc adjustments to the final decision requirement of 1291. To the extent this doctrine is still recognized, it must be invoked only in truly "unique instances," and not when the dispute can be adequately reviewed on appeal from a final judgment. We have questioned the pragmatic finality doctrine's continued viability for the last 15 plus years, and continue to do so after Mohawk. Defendants argue that the present appeal is a unique or exceptional circumstance, because this court has not decisively answered whether federal or state law governs the privilege asserted. However, defendants neither explained the importance of deciding this legal issue on immediate appeal, nor have defendants shown that the danger of injustice by Della 5ENG appellate review outweighs the inconvenience and costs of piecemeal review. Defendants' interests in immediate review center on their desire to prevent information they deem privileged from disclosure, but the Supreme Court has already found such interests insufficient to warrant immediate appeal. Edit 1204206, 1209-10. B. Avoidance or evasion of the basic concept mandamus read 28 U.S.C. 1651. In the supplement. Larby v. House Leather Co. Supreme Court of the United States, 1957, 352 U.S. 249, 77 S. Court 309, 1L edition 2nd 290. Certiorari to the United States Court of Appeals for the 7th Circuit. Justice Clark delivered the opinion of the court. These two consolidated cases present a question of the power of the courts of appeals to issue writs of mandamus, to compel a district judge to vacate his orders entered under Rule 53(b), referring antitrust cases for trial before a master. The petitioner, a United States district judge, contends that the courts of appeals have no such power and that, even if they did, these cases were not appropriate ones for its exercise. The Court of Appeals for the 7th Circuit has decided unanimously that it has such power and, by a divided court, that the circumstances surrounding the references by the petitioner required it to issue the mandamus about which he complains. Secretary. The principle of finality 1175 history of the litigation. These petitions for mandamus from two antitrust actions instituted in the district court in 1950. JJ involves 87 plaintiffs and 6 named defendants. Schaffer involves 6 plaintiffs and 6 defendants. The record indicates that the cases had been burdensome to the petitioner. In Rolfing alone, 27 pages of the record are devoted to docket entries reflecting that petitioner had conducted many hearings on preliminary pleas and motions. It is reasonable to conclude that much time would have been saved at the trial had petitioner heard the case because of his familiarity with the litigation. The cases were called on February 23, 1955. On a motion to reset them for trial, the petitioner announced that it has taken a long time to get this case at issue. I remember hearing more motions, I think this case than any case I have ever sat on in this court. The plaintiff CS ed that the trial would take 6 weeks, whereupon petitioner stated he did know when he could try the case. If it is going to take is long, he asked if the parties could agree to have a master hear it. The parties ignored this query, and at a conference in chambers the next day petitioner entered J orders o caritari ference soispont. The orders declared that the court was confronted with an extremely congested calendar and that exception sick conditions exist for this reason requiring the references. The cases were referred to the master to take evidence and to report the same to T court, together with his findings of fact and conclusions of law. Upon petitioner's refusal to vacate the references, these mandamus actions were filed in the Court of Appeals seeking the issuance of writs ordering petitioner to do so. These applications were grounded on 28 U.S.C. 1651, the All Writs Act, declaring that the references amounted to a refusal on his petitioner's part, as a judge, to try TE causes in due course. The Court of Appeals concluded that in view of the extraordinary nature of these causes the references must be carried find that the orders were beyond the court's power under the pertinent rule. And, it being so found, the writs issued under the authority of the All Writs Act. The power of the courts appeases petitioner contends that the power of the courts of appeals does not extend to the issuance of so mandamus to review interlocutory orders, except in those cases where review of the case on appeal after final judgment would be frustrate. The question of naked power has long been F. as Roche v. Evaporated Milk Association, 1943, 319 U.S. 21, 25, 63 S. 938, 941, 87 L edition 1185. Mr. Chief Justice Stone reviewed the decisions, and in considering the power of courts of appeals to issue writs of mandamus, the court held that the common law writs, like equitable, as in original 0 as in original, 1176 Appellate Review Chapter 16 remedies, may be granted, or withheld in the sound discretion of the court. Since the Court of Appeals could at some stage of the antitrust proceedings entertain appeals in these cases, it has power in proper circumstances, as here, to issue writs of mandamus reaching them. The discretionary use of the writs, it appears from the docket entries to which we heretofore referred, that the petitioner was well informed as to the nature of the antitrust litigation. Nevertheless, he referred both suits to a master on the general issue. Furthermore, neither the existence of the alleged conspiracy nor the question of liability vel non had been determined in either case. These issues, as well as the damages, if any, and the question concerning the issuance of an injunction, were likewise included in the teferences. Under all of the circumstances, we believe the Court of Appeals was justified in finding the orders of reference were an abuse of the petitioner's power under Rule 53(b). They amounted to little less than an abdication of the judicial function, depriving the parties of a trial before the court on the basic issues involved in the litigation. The use of masters is to aid judges in the performance of specific judicial duties, as they may arise in the progress of a cause. Ex parte Peterson p. 949. Super, and not to displace the court. The exceptional circumstances here warrant the use of the extraordinary remedy of mandamus. It is also contended that the 7th Circuit has erroneously construed the All Writs Act as conferring on it a roving commission to supervise interlocutory orders of the district courts in advance of final decision. Our examination of its opinions in this regard leads us to the conclusion that the Court of Appeals has exercised commendable self-restraint. It is true that mandamus should be resorted to only in extreme cases, since it places trial judges in the anomalous position of being litigants without counsel other than uncompensated volunteers. However, there is an end of patience, and it clearly appears that the Court of Appeals has, since 1938, admonished the trial judges of the 7th Circuit that the practice of making references does not commend itself, and should seldom be made, and if at all, only when unusual circumstances exist. Still, the Court of Appeals did not disturb the reference practice by reversal or mandamus until this case was decided in October 1955. The record does not show to what extent references are made by the full bench of the district court in the Northern District. However, it does reveal that petitioner has referred 11 cases to masters in the past 6 years. But even a little cloud may bring a flood downpour if we approve the practice here indulged, particularly in the face of presently congested dockets, increased filings, and more extended trials. Be that as it may, congestion in itself is not such an exceptional circumstance as to warrant a reference to a master. If such were the test, present congestion would make references the rule, rather than the exception. Petitioner realizes this. TTTTC Principle of Finality 1177 seconds. For in addition to calendar congestion, he alleges that the cases referred had unusual complexity of issues of both fact and law. But most litigation in the antitrust field is complex. It does not follow that antitrust litigants are not entitled to a trial before a court. On the contrary, we believe that this is an impelling reason for trial before a regular, experienced trial judge, rather than before a temporary substitute PPONTED on an ad hoc basis and ordinarily not experienced in judicial work. We agree that the detailed accounting required in order to determine the damages suffered by each plaintiff might be referred to a master after the court to remind the overall ability of defendants, provided the circumstances indicate that the use of the court's time is not warranted in receiving the proof and making the tabulation. VF affirmed. Justice Brennan, with whom Justice Frankfurter, Justice Burton and Justice Howland join, dissenting. The case before the Court of Appeals was not a case where a court has exceeded or refused to exercise its jurisdiction. Rule 53(b) vested Judge Labai with discretionary power to make a reference it. He found, and he did, that some exceptional condition required the reference. If Judge Labai erred in finding that there was an exceptional condition requiring the reference, or did not carry proper weight to the caveat of the rule that a reference to a master shall be the exception and not the rule, that was MERE carried ERROR. In ruling on matters within the district court's jurisdiction. But regrettable as is this court's approval of what I consider to be a clear departure by the Court of Appeals from the settled principles governing the issuance of the extraordinary writs, what this court says are reaching its result is reason for particularly grave concern. I think this court has today seriously undermined the long-standing statutory POIC against piecemeal appeals. My brethren say, since the Court of Appeals could at some stage of the antitrust proceedings entertain appeals in these cases, it has power in proper circumstances, as here, to issue right of mandamus reaching them. I understand this to mean that proper circumstances are present for the issuance of a writ in this case. Because either litigants are not now heard, the Court of Appeals will no opportunity to relieve them of the burden of the added expend and delay of decision alleged to be the consequence of the reference. But that BNG was crossed by this court in Roche. What this court is saying, therefore, is that the All Writs Act confers an independent appellate power in the courts of appeals to RC**W interlocutory orders. I have always understood the law to be precisely the contrary. 1178 Appellate Review Chapter 16. The power of the Courts of Appeals to issue extraordinary writs stems from 14 of the Judiciary Act of 1789. Chief Judge Magruder, in Henry Josephson, 1 C. 218 F. 2nd 174, provides us with an invaluable history of this power and of the judicial development of its scope. He demonstrates most persuasively that the All Writs section does not confer an independent appellate power. The power is strictly of an auxiliary nature, in aid of a jurisdiction granted in some other provision of law. The focal question posed for a court of appeals by a petition for the issuance of a writ is whether the action of the district court tends to frustrate or impede the ultimate exercise by the court of appeals of its appellate jurisdiction granted in some other provision of the law. The answer is clearly in the affirmative where, for example, the order of the district court transfers a cause to a district court of another circuit for decision. That was Josephson, where the effect of the order is that the district judge has declined to proceed with the determination of a case which could eventually come to this court by appeal from a "final decision." In contrast, a district court order denying a transfer would not come under the umbrella of power under the All Writs Act, since retention of the cause by the district court can hardly thwart or tend to defeat the power of the Court of Appeals to review that order after final decision of the case. The view now taken by this court, that the All Writs Act confers an independent appellate power, although not so broad as to authorize the indiscriminate use of prerogative writs as a means of reviewing interlocutory orders, in effect engrafts upon federal appellate procedure a standard of interlocutory review never embraced by the Congress throughout our history, although it is written into the English Judicature Act, and is followed in varying degrees in some of the states. That standard allows interlocutory appeals by leave of the appellate court. Notes and questions 1. In Sklagenhoff v. Holder, 379 U.S. 104, 85 S. Court 234, 13 L. Edition 2nd 152, 1964, the substantive aspects of which are set out at p. 882, supra. The court upheld the use of mandamus to review an order requiring a defendant to submit to a physical and mental examination. It is, of course, well settled that the writ is not to be used as a substitute for appeal, even though hardship may result from delay and perhaps unnecessary trial. The writ is appropriately issued, however, when there is usurpation of judicial power or a clear abuse of discretion. The challenged order appears to be the first of its kind in any reported decision in the federal courts under Rule 35. Secretary, a THF, Principle of Finality 1179. It is thus appropriate for us to determine on the mercy issues presented, and to formulate the necessary guidelines in this area. This is not to say, however, that following the setting of guidelines in this opinion, any future allegation that the district court was in error in applying these guidelines to a particular case makes mandamus an appropriate remedy. Ed. at 110-12, 85 S. Court at 238-239, 13 L. Edition 2nd at 156-60. 2. Many of the Supreme Court's X*TMT-TMD estates 389 UTM concerned discovery disputes. Compare Will v. United States X set 269, 19 L. Edition 2nd 305, 1967, a criminal case in which the government sought mandamus to overturn a district discovery for the defendant. The Court of Appeals granted the writ. I Supreme Court reversed, stating that the facts did not reveal an extraordinary YSZ for which the writs must be reserved. The court fact that without mandamus the government cannot obtain guidance discovery matters, since it cannot appeal an acquittal. Relying heavily on will, the Supreme Court in Kerr v. United Vertical Bar Tates NISDRTCT Court 426 U.S. 394, 96 S. Court 2119, 48 L. Edition 2nd 72, SDI'd mandamus by a Court of Appeals in a civil case in which the trial judge had ordered defendants, state correction officers, to turn over to CS a number of prisoner personnel files. Defendants AR ED that such discovery should be compelled only after a determination li 1 inch. That plaintiff's need for the information outweighs. Court reiterated the reasons to permit use of writs appeals, and also recognized that the jurisdiction in the technical sense would be too narrow. The court assuming that the trial judge would accept its suggestion to review EAJOI's NALC in Lera to determine if discovery should be permitted. Thus Mahiriga writ unnecessary. In Nixon v. Sirica, 487 F. 2nd 700, 707, DCC 1973, a district judge ordered the President of the United States to produce certain tape recording for the judge's inspection prior to a determination whether the recordings WBC teat frere and jury subpoena. The President petitioned for a writ of dismissal. The Court of Appeals, although LYFLV R4 Deg. Serii merits, held that mandamus was an APPROP-TEX-S in light of the great public interest in prompt resolution of the issues 3 and Cheney v. United States District Court, 542 U.S. 367 Teed, holding that it was error to treat the assertion of the privilege as a 1180 Appellate Review Chapter 16 necessary precondition to mandamus, and remanded to permit the appeals court to consider whether the writ should issue. In Cheney, the SUPREME-COURT not L test for issuance of the writ of mandamus, there must be burden of showing that the right to relief is clear and indisputable, and the issuing court in its discretion must be satisfied that the writ is appropriate under the circumstances. Ed. 380-81124 S. Court at 2587, 159 L. Edition 2nd at 477, Land TM degrees IED. Why would the issuance of THTPN S R H discovery dispute ever meet this test? See Fullerton, Exploring Reaches of Mandamus, 49 Brooklyn L. Reverend 1131, 1152, 1983. For a privilege claims, see Robertson, Appellate Review of Discovery Orders in Federal Court, a suggested approach for handling privilege claims, 81 Washpoint L. Reverend 733, 756-58, 2006. 4. Mandamus relief as a form of interlocutory review is used sparingly. As a result, many intermediate procedural decisions by the district court that may have profound implications for the lawsuit are not reviewed when SRL judgment is entered. These interlocutory decisions include change of 28 U.C.T.M.P.P. N. Entel Point descent under 28 U.S.C. 1367. C. Remand of an action removed as a matter of diversity U CTL 407 NL point rendered in multi-district litigation under 28 of THLLW Perspective Trust WTL. Review and correction, legal uniformity, and public trust. Would it be appropriate to provide a method of appeal other than mandamus for these issues? C. Displacement of the basic concept discretionary appeals read 28 U.S.C. 1292 B and 1292 E in the supplement. Atlantic City Electric Co. v. General Electric Co. United States Court of Appeals, 2nd Circuit, 1964, 337 F. 2nd 844. PPPSBPPT to Section Re 0 Objections to interrogatories, signed to discover whether damages were actually sustained by plaintiffs who may have shifted such damages, if any, to their customers of electricity, involves a controlling question of law in these litigations and that there is substantial ground for differences of opinion. In sustaining the objections to the interrogatories, pose the district court has, in effect, foreclosed defendants from pre-trial discovery of facts relating to a defense that plaintiffs have passed on to their customers any secretary, the principle of finality 1181 damages incurred by plaintiffs and hence are not entitled to recover to the extent that defendants can prove such passing on. Upon this application for leave to appeal, it would not be appropriate to isolate and endeavor to decide before an appeal from any final judgment this particular question of law. Pre-trial leave to appeal applications must be decided against the background of the entire case. Many important questions of law will undoubtedly arise in these cases, but the problem now confronting us is the feasibility and advisability of trying to decide this particular question in advance of trial. If pre-trial discovery were allowed as defendants request, it could easily develop into a multitude of full-scale rate cases which could dwarf in time and testimony the already extensive pre-trial proceedings. If the district court is in error, defendants will have full opportunity in the event of an adverse judgment, if based in whole or in part upon this error, to have it corrected upon appeal together with any other errors which may be urged. It is doubtful that any discoveries or hearings required to establish the extent of any damages, if the passing on doctrine applies, would be more burdensome then than now. Since defendants' rights to this defense are not being taken away or prejudiced on any ultimate appeal by denial of the pre-trial appeal now sought, we believe that the ultimate disposition of these cases would be delayed, rather than advanced by granting this application. Application denied. Notes and questions 1. Under 28 U.S.C. 1292 B. The court considers many of the same factors used to determine whether there is no just reason for delay for the issuance of a Rule 54 B certificate. In what respects do the two statutes differ? 2. When is a question of law considered to be controlling or subject to a substantial ground for disagreement? Must the issue be dispositive of the lawsuit in order to be considered controlling? Is it sufficient that the issue could produce reversible error on final appeal? Does the parties' strong disagreement with the district court's ruling deserve any weight? For a discussion of these questions and an emphasis on the exceptional nature of review under 28 U.S.C. 1292 B, C in re-cement antitrust litigation, 673 F. 2nd 1020, 9th C 1982. 3. Is review under 28 U.S.C. 1292 B limited to the question that the trial court identifies in its certified order, Yamaha Motor Corp v. Calhoun, 516 U.S. 199, 116 S. Court 619, 133 L. Edition 2nd 578, 1996, involved the death of a 12-year-old in the territorial waters off Puerto Rico while riding a jet ski manufactured by petitioner. The district court certified the question of whether particular items of damage were available in a federal maritime wrongful death action. The Third Circuit granted interlocutory review, but then considered the antecedent question of whether state remedies remained 1182 Appellate Review Chapter 16 available in maritime accidents of this sort. The Supreme Court held that, although jurisdiction under Section 1292 B is limited to the order certified by the district court, it is not tied to the particular question formulated by the district court. Rather, the appellate court may address any issue fairly included within the certified order, because it is the order and not the controlling question that is appealable. Edit 205, 116 S. Court at 623, 133 L. Edition 2nd at 585. Compare United States v. Stanley, 483 U.S. 669, 677, 107 S. Court 3054, 3060, 97 L. Edition 2nd 550, 562, 1987. Jurisdiction does not reach any other orders that may have been entered in the case for. Since 1992 the Supreme Court has had power pursuant to 28 U.S.C. 1292 E to promulgate rules permitting interlocutory appeals from any orders that it deems appropriate. So far, the court has used this power only once, to add Federal Rule 23 F pertaining to the appeal of class certification decisions. How supra would have rule does 23 F rule effect 23 F differ the result in operation in Coopers from and 28 Librand, USC. Note 1290 to caret 5 P 1172 5 in Microsoft Corp v. Baker, 137 S. Court 1702, 198 L. Edition 2nd 132, 2017. Consumers filed a putative class action after the district court denied class certification and denied permission to appeal the denial under Federal Rule 23-F. Plaintiffs voluntarily dismissed their individual claims with prejudice, but reserved the right to revive the claims if the district court order was reversed on appeal. The Supreme Court held that the voluntary dismissal did not qualify as a final order under 28 U.S.C. 1291, and that allowing an L. Edition 2nd appeal would at 146 undermine Rule 23-F.'s careful calibration. Edit 1715, 198, 6. Should the court's ruler-making power be used to authorize mandatory interlocutory review for the situations identified in Note 4, P 1180, Supra, C. Glein, discontent and indiscretion, discretionary review of interlocutory orders, 77 Notre Dame El Reverend 175, 180, 2001. Would it be advisable to limit such review to questions of unsettled law? D. An historical footnote to the basic concept injunctions read 28 U.S.C. 1292, 1, and Federal Rules of Civil Procedure 65, and B. In the supplement. Smith v. Vulcan Iron Works, 165 U.S. 518, 525, 17 S. Court 407, 410, 41 L. Edition 810, 812, 1897. The manifest intent of this provision, read in the light of the previous practice in the courts of the United States, contrasted with the practice in courts of equity of the highest authority elsewhere, appears to this court to have been, not only to permit the defendant to obtain immediate relief from an injunction, the continuance of which throughout the progress of the cause might secretary, the principle of finality 1183 seriously affect his interests, but also to save both parties from the expense of further litigation, should the appellate court be of opinion that the plaintiff was not entitled to an injunction, because his bill had no equity to support it. Notes and questions 1. What is the justification for allowing appeals from interlocutory orders granting or refusing injunctions? Do these reasons apply to orders granting or denying preliminary injunctions? I work Justice W.E. Carrot relegate the parties to discretionary appeals under 28 U.S.C. 1292, b. W. Why is it significant that injunctive orders are outside the scope of Federal Law 54, b. Question mark 2. Is the grant or denial of a temporary restraining order under Federal Rule 65, b. appealable? See 28 U.S.C. 1292, 1. Are the differences between preliminary injunctions and temporary restraining orders relevant to the question whether appeal should be permitted in the case of the latter? In close cases it may be difficult to tell you the difference between a preliminary injunction and a temporary restraining order in United States v. Wood, 295 F. 2nd 772, 5th C. 1961, cert. Denied. 369 U.S. 850, 82 S. Court 933, 8 L. Edition 2nd 9. 1962, a black man who was active in voter registration in Mississippi was arrested for disturbing the peace and ordered to trial in 15 days. 2 days before trial, the earned head under 42 U.S.C. 1971, and alleging that the prosecution would intimidate African Americans in the exercise of their voting rights, brought suit to restrain the criminal action. A temporary restraining order was denied and government appealed. The Court of Appeals held that it had jurisdiction UND Section 1291. Inasmuch as the case would quickly become moot if the restraining order was not issued, the court said its denial was a finite disposition of the claimed right. To call this de facto an unappealable interlocutory order is to preclude review altogether. Eder in Gulfstream Aerospace Corp v. Mayacamas Corp. 485 U.S. 271, 108 S. Court 1133, 99 L. Edition 2nd 296, 1988. The Supreme Court resolved that a district court's denial of motion to stay or dismiss legal proceedings on equitable grounds is not automatically appealable under 28 UBU 1291. 1. Under Gulfstream, an order that has 292. 2. If it granting or denying an injunction is appealable under 28 U.S.C. 1292, has serious irreparable consequence. 3. Does the appeals court retain jurisdiction under 28 U.S.C. 1291, if during the pendency of the appeal the district court enters a final judgment that incorporates the same relief as the preliminary Birmingham Firefighters Act 117 v. City of Birmingham, 603 F. 3rd 1248, 1254 55, 11th C. 2010.